Now, the American law and the Fourth Amendment protection against the unreasonable search and seizure. It is provided under next chapter. The scope of the mandate, as mentioned in the first part of this module, is presently being deliberated before the Supreme Court of the United States, which started hearing submissions in various cases such as Riley versus California and United States versus Vury on the 29th of April 2014. The point for the consideration was if the investigating officers should be permitted to pursue the mobile phones of persons upon lawful detention without gaining a precise warrant for the search. The cases relate the events where the accused was in detention because of a minor breach and search without warrant was laid, which comprised the search of cell phones in their custody. The information exposed in the phones eventually managed to the evidence added crimes and the sentence of the accused of serious offense the sentence of the accused of serious offense. The appeal is to surpass the evidence so acquired on the basis that the search disrupts. Even though there have been an overabundance of inconsistent choices by numerous subordinate courts, including the judgment in Vury and Riley, the Federal Supreme Court will be for the first time determining the question whether the mobile phone searches should need a greater higher onus under the Fourth Amendment. The Fourth Amendment in the Constitution of the United States specifically provides the safeguard against the unwarranted searches and confiscation. Nonetheless, the discretion has been given to the court to appreciate situation in which the right to non-intervention would go better to the interest of attaining information in every case in absence of the precise definition of the term unreasonable, leading to comprehensive and diverse jurisprudence on that matter. The jurisprudence originates from the extensive Fourth Amendment safeguard against unreasoned government intrusion, where the law is usually that any search without warrant is unreasonable except enclosed by sure exclusions. The basis for the safeguard under the Fourth Amendment has an individual standard which is decided on as per subjective psychological consideration than that of any objective consideration such as physical location and encompasses to all conditions where people have rational expectation of privacy, that is circumstances where people can reasonably believe to have privacy, which is a subjective criteria and not absolute reliant on the tangible location of the search. Therefore, the condition of reasonableness is generally only satisfied once a search is accomplished following to the issuance of warrant from an unbiased judge by providing credible reason to be certain of the evidence of any illegal action would be based upon such search. Hence, the warrant is therefore a significant restriction on such authorities of the investigating officers. Additionally, the safeguard accepts roving or overall searches and needs accuracy of articles to be searched. The limitation originates its authority from the exception rule, which creates a bar to the evidence acquired through unwarranted search or confiscation found straight away or through added warrants founded upon such evidence from being used in succeeding prosecutions. Though there have developed numerous exclusions to the general rule which inculcates cases where the search proceeds on legitimate detention of an accused, a process which is justified by the prospect of unseen weapons upon the accused or of damage caused to the key evidence. Finding an individual these days would not only amount to the recovery of calling cards or cigarettes, but the cell phones and PCs, which can be the virtual record of the individual's life, somewhat that could not have been anticipated when the rules were drafted. Mobile phones and computer hunts are the alike or of searches of the records, pictures and individual records, and these and of privacy in these cases is greater than in usual searches. Courts have previously considered that cell phones and laptops are atoms in which the operator may have a rational belief of privacy by assembling them corresponding to a padlock flask which the law enforcement agency cannot explore and therefore impending under the safeguard of Fourth Amendment. However, the other side provides mobile phone and PCs also clutch the data that can be helpful in examining criminal action, and with tools like secluded smears of accessible computer records. This kind of record is continuously in danger of damage of investigation happen if the investigation happens late. On the basis of the verbal opinion being received now, it appears that the court is figuring out an exact standard appropriate to novel technologies. The court is expected to bring together delicacies precise to the technology involved. Now, the next chapter, which provides for search and seizure in India. Indian jurisprudence on privacy is comprehensive from that of the jurisprudence in USA. Nevertheless, it is hard to stringently sort the several aspects of right to privacy. There is no direct or implied reference of such right in Indian Constitution. Even if judiciary has acknowledged the significance of practical safeguards in guarding the perverse governmental intrusion, the appreciation of the inherent right to privacy as non-interference, which may be different from the contributory rights which criminal procedure pursue to protect, such as abuse of police authority, is deeply missing. The general law has provided that for the country's authority of search and confiscation of the evidence is provided in the Code of Criminal Procedure 1973. Section 93 of this code offers for overall practice of search. Section 93 provides that for a magistrate to issue a warrant for the search of any document or thing, including warrant for general search of an area where it believes it is required for the purpose of investigation. The meticulousness of the search warrant is not a condition under section 93 subsection 2. Therefore, a warrant might be a common or roaming search of a place. Section 100, which additionally states that for the search of a closed place, it includes certain protections such as attendance of witness and prerequisite of warrant before the police officer may be permitted access into the closed place. However, under section 165 and section 51 of the code, the necessities of a such warrant are discharged. Section 165 bestows the warrant prerequisite and offers for an officer in charge of a police station or any other officer duly approved by him to execute the search of any location as long as he has the reasonable basis to trust that search would be for the preservance of an investigation and confidence that such warrant cannot be acquired without undue delay. Additionally, the officer leading such search must, as far as possible, write down the details for search certainly in writing prior to undertake such search. Section 51 provides that another express exception to the condition of search warrants by permitting the search of an individual detained legally, provided that detained individual might not be granted a bail and needs any such seized item to be in black and white in a search memo. As long as these circumstances are satisfied, the IO has absolute control to the search an individual upon detention, where the detainee can be granted bail as per the warrant, or in cases of even the arrest without warrant as per the legislation. The search and seizure of such person may not be regular one, and the evidence so gathered would be conditioned to subject to more scrutiny by the court. However, despite of nominal safeguards, there is no added procedural safeguard or individual privacy, and the authorities of the search of the investigating officer are tremendously comprehensive and unrestricted. Actually, there is a lack of uh, exceptions rule as safeguard as well. It shows that unlike under the 4th Amendment under US law, the non-compliance with the practical conditions of search would not by itself make the proceeding infructuous or defeat the evidence so established, but would only subject to an irregularity which must be just extra aspect accepted in assessing such evidence. Unreasonable intervention in personal matters by the state is a beneficial standard to assess privacy, since it attributes a concept of privacy as an inherent right as well as contributory one. That is, privacy as a non-interference is a good in itself, despite of the rights it helps to achieve. For example, rights such as freedom of movement or freedom of speech. Concerning digital privacy in precise, Indian law and policy has become unsuccessful to meet the challenges that new technology pose to privacy and has in fact been reverting by involving in surveillance of online transactions and by permitting governmental right to use the online information like emails, website, logs without the judicial check. In the era of ICT and of privacy being located at more risk, laws which were once considered rational now have become absolutely insufficient in ensuring freedom and liberty as provided by the right to privacy. The discrepancy is even more noticeable in cases of investigation of cybercrimes, which depend on almost entirely on electronic evidence, such as those essentially provided under the Information Technology Act, but investigated under the oral process involved in the code of as provided in the Code of Criminal Procedure as mentioned above. The process for the investigation of the cybercrimes and search and seizure of electronic evidence need special acceptance and must be brought in a line with modified shifting standards.